definition of worker we need to understand. It includes working journalists and sales promotion employees. Now, many of the companies which are pharmaceutical companies will be very much concerned about this, and they are very much concerned about the sales promotion employee. What does the Act say? So it covers these people, and it talks about also those who are not included. Okay, so those who are engaged in supervisory capacity and drawing more than 15,000 rupees. The salary limit of 10,000, which was there earlier in the Industrial Disputes Act, has now been revised to 15,000 rupees. So many supervisors who are drawing less than 15,000 will be considered as workmen. So this is also required to be noted by companies, that if your supervisory salaries are less than 15,000, they would be considered as workmen under the Industrial Disputes Act. So the definition of workman gives way to the definition of worker, and the supervisory and management are excluded with the salary limits of supervisory personnel revised upwards from 10,000 that was prevailing under the erstwhile law, now being raised to 15,000 rupees. Payment of Wages Act ceiling of 24,000 now removed. All employees, including supervisory and management, will have access to the machinery for enforcing their claims. Payment to be made within 48 hours, and for unclaimed wages benefits within 6 months to be deposited with the authority. So this is a very new thing that has happened. You have to settle their claims within 48 hours, and any unclaimed wages will have to be compulsorily deposited with the authority. Then definition of contract labor. Now this act also talks about a new thing which was not there in the earlier environment of what is contract labor. And it says that who is not a contract worker, it also covers, contract labor would also cover interstate migrant worker, but does not include a worker other than a part-time employee. Part-time employee also will not be included. Who is regularly employed by the contractor for any activity in his establishment. His employment is governed by the mutually accepted standards of the conditions of employment, including engagement on permanent basis. So any employee who has been employed by the contractor on permanent basis will not be contract labor. He also has to get periodical increments in pay, social security coverage, and welfare benefits in accordance with the law. Okay. So this is what it is. Then Minimum Wages Act, the provision of the Minimum Wages Act, basically the Supreme Court judgment in Raptocos Brecht will become the basis. It will push up the minimum wages in the employment. The scheduled employments have been disbanded. Skill-based wages uniformly to apply across industries. Wage fixation process largely similar, a tripartite process and boards consisting of interested parties. Now, two things which are new, which I think will be very relevant for you to understand. If an employee whose minimum rates of wages has been fixed under the code for the day works on any day on which he was employed for a period less than the requisite number of hours that constitutes a normal working day, that he is working for less than 8 hours. Say he works for 5 hours. Okay. He will be entitled and eligible to receive full day's wages though he has worked for 5 hours. Unless your contract provides for something different. So now this is something which is very important to understand. If your contract doesn't provide that he should be paid on an hourly basis, he can be eligible for full day's wages. Okay, and there is a condition that he should not refuse the wage. Okay. Then what the new code entails: equal remuneration to be paid to employees irrespective of gender, and also for the same work or work of a similar nature done by an employee. And the government notified person is empowered to decide on disputes with regard to same or similar nature of work. So if contract workers are employed on similar work like permanent, you are likely to have more disputes that would be decided by the executive authority and not by the judiciary. Section 17 of the code mandates payment within 2 working days, removal, dismissal, retrenchment, or his resignation, and deposit with the Deputy Chief Labour Commissioner within 6 months of the amount payable to be claimed by a person within 7 years. They can claim it within 7 years. But within 6 months, if an amount is not claimed, you have to, surrender that amount to the Deputy Chief Commissioner, who will keep that money with him for 7 years and then return it to the government. So this is how it will be. This is the new thing in the code. Then look at the definition of same work or similar nature, work of a similar nature. Same work or work of a similar nature means work in respect of which the skill, effort, experience, and responsibility required are the same when performed under similar working conditions by employees. And the difference, if any, between the skill, effort, experience, and responsibility required for employees of any gender are not of practical importance in relation to the terms and conditions of employment. This is a very sweeping statement. Anybody can do the same work, and the executive authority will decide whether he should be paid the same wages or not. In many companies, permanent workers of companies are paid much higher, 3 to 4 times higher than what a contract worker is paid for doing the same work. So you are likely to have a lot of disputes on this.